Gary Wrigley versus Men on Move, Inc.
Your Honor, Joe Lloyd appearing on behalf of the defendant.
Oh, Mr. Lloyd.
Good morning or afternoon, Natalie Benici.
Oh, you're back? No, I'm kidding.
I know.
What is this? I said, geez, one case, she's out. No, go ahead.
Yes, I'm filling in for John Bedeen this afternoon from the same firm.
All right.
And to my left is the plaintiff.
All right. All right. Where are we on this case?
Your Honor, this is a termination of tenancy, and we have a subsequent civil action going on that was filed recently regarding the business. So my client owns the building. He's a silent partner, 50% interest in the business that rents from his building.
Got it. I think.
So
he's a 50%. So he's a 50% owner.
Correct.
Basically of the building, but
he 100% owns the building, and the business that rents from him, he's a 50% silent partner.
Got it.
Yeah. So there's an issue.
So he's half of him has to go to this side. No, I'm kidding.
I'm not his lawyer.
Oh my. Okay. Oh, this would be fun. All right. Okay, got it.
Yeah, so what we're requesting today, I did have a chance to speak with brother counsel. We are requesting a pretrial in about 90 days. The parties would like some time to conduct discovery regarding the civil action and hopefully come to a global resolution.
Okay, so let me ask you this. Where is the civil action?
Washington Circuit.
Okay.
Yes, in business court.
Got it. So you're trying to work out some of that through the business court, which ultimately potentially could resolve some of what's here or all of what's here.
Correct.
Is that?
I believe.
Okay.
Oh, sorry. And one more thing, we are requesting.
See, I was going to say that was so easy, and I knew she was going to say something. No, go ahead.
We are also requesting that escrow be paid through the court. Through the defendant's prior attorney, he represented that the defendant was holding escrow at $4,500 a month. That is the fair rental value. And we just ask that in the interim that the court enter an escrow order.
At this point, the case shifts from a straightforward possession dispute into something much more complex. The plaintiff isn't simply asking the court to decide who has the right to occupy the property. They're asking Judge Simpson to require ongoing escrow payments while the litigation continues. That matters because escrow isn't a final ruling on liability. It's a tool designed to preserve the status quo and prevent one side from benefiting while the legal dispute remains unresolved. Notice how both attorneys immediately begin narrowing the legal issue. One side argues that an escrow order is necessary because rent continues to accrue, while the defense questions whether escrow is even appropriate in a case focused solely on possession. That's an important strategic distinction. If the judge accepts the defense's framing, the financial dispute belongs elsewhere. If he accepts the plaintiff's position, the defendant could be required to deposit significant monthly payments before the underlying business conflict is ever resolved. Did you notice Judge Simpson isn't rushing toward an answer? Instead of reacting to the request itself, he's identifying exactly what legal authority he has before deciding whether an interim remedy is justified. That careful approach often signals a judge who intends to build a ruling that will withstand later challenge.
If I may address that, Your Honor.
Certainly.
One, Mr. Reach was the previous lawyer. I called him here, and there is no money actually in escrow with him. And the second thing, there's not a money claim in this. This is purely a possession claim. So I'm not sure that escrow.
Well, certainly, even if it's a possession case, escrow can be ordered. It's just, I mean, the remedy, if it's not paid, I don't know if that gets you folks to the point that you would want to be in any event, but okay. Go ahead.
I'm going to make a proposal. What I don't have is, I don't know if my client even wants to contest the escrow. What I was going to suggest is if you wanted to enter an order, I'd want to reserve the right to come back and revisit the merits of it. in a week or 2 weeks, but you shouldn't have to come back if the client agrees. I just haven't been able to address the question with my client. So,
Right, and I guess I also have the business. This is a little bit complicated, or maybe I'm making it more complicated in my head. If the plaintiff is a 50% owner of the business, then go ahead.
well,
Mr. Lloyd.
because what happens, I think, I mean, the business is a separate entity, it's an LLC.
Right.
So I'm exploring that as a possible defense, but I haven't given it serious thought at the moment. I understand the conundrum, and if I raise it, I will raise it with authority in mind.
Okay, because, well, part of what I'm thinking, despite his ownership, to what extent your client's ownership was, the company was the one that paid the rent. Is that
Yes.
correct? Okay.
Yes, and the rent was $2,500, or excuse me, yes, $2,500 a month. And then as of January, the two partners agreed that they would pay an extra $600 a week. They were converting payroll into rent. So the rent price went up.
Doing what?
Sorry, to keep it short, the business was paying for rent. The proceeds
Yeah.
came from the business.
Got it.
Your Honor, I am confused now. I'm in over my head in terms of the facts of the case, because I'm not handling the circuit court case.
Oh, you're not.
I am not,
I'm
so
not.
I'm a little,
And you're not.
No, I'm
Oh,
filling
just
in.
beautiful.
we're just here.
I thought you guys were the ones in circuit, but no.
No, I'm here for John
Okay.
Dedeen today.
We're just the.
Got it. Okay, so here's what I'll do. I will give you so counsel, what was then your understanding then of, it was $2,500 per month, but then it changed
Correct.
to
It changed to the $4,900 in February.
$4,900
Correct.
per month?
Yes. And they paid that for 1 month and then completely stopped paying rent. So the last payment was in February.
Okay. That's a significant change. And I guess I'm trying to figure out what motivated that change. Whoever can explain it to me.
My partner wanted to buy me out. And I agreed, it's time for me to get out. He sent me an offer which basically said, give me the business. I turned down that offer. Then he said, I'm not paying you. And I said, that's crazy. He goes, I'm just not paying your salary, I'm not paying your rent, I'm paying nothing. And they just stopped paying.
Okay, no, I get, well, I don't get, but the reason for not paying, what I'm trying to figure out is the rent was at $2,500 per month. At some point goes to 49, basically doubles.
I had a salary of $600 a week. And he asked me, can we roll the salary of $600 a week into the monthly payment? And I said, okay, since we're going to be trying to work out a buyout. And then they just stopped paying me. They made one payment 1 month. So I don't know why.
Got it. So the reality is the additional 2,400 really isn't rent.
Right.
It really is your salary. Right? I mean, I get what you guys may have been calling it,
Yeah,
but that's
what they asked me to do.
I hear you,
Yeah.
but so that you understand, sir, I get what you're saying. For my purposes, in determining escrow, someone's salary would not be included in
Well,
what I would set escrow.
This is arguably the most legally significant moment in the hearing. Judge Simpson has just separated two financial concepts that the parties had been treating as one. Throughout the discussion, the plaintiff explained that an additional weekly payment had been rolled into what everyone was calling rent. But the judge looks beyond the label and asks what those payments actually represented. That's a classic judicial approach. Courts generally evaluate the substance of an agreement rather than the terminology the parties choose to use. If part of the payment functioned as compensation for work rather than payment for possession of the property, combining everything into one escrow figure could unfairly distort the issue before the court. Notice something else. Neither attorney is being accused of misleading the court, but both are being pushed to separate facts from assumptions. The defense emphasizes that these financial disputes belong in the business litigation, while the plaintiff relies on the court's authority to protect the landlord's interests during the possession case. Those are two very different litigation strategies aimed at the same judge. Which argument would persuade you more? The one focused strictly on possession, or the one asking the court to account for the broader financial relationship between the partners? That distinction is likely to shape the remainder of the hearing.
I understand. And the rent was significantly below market value, and partially because he was, an owner of the building. But I do have the email from the prior attorney saying that the defendant was placing an escrow a sum of $4,500 a month. So they agreed that that was the price of escrow. And I can provide
$4,500,
$4,500. So that's
but rent was 49.
as of February, but we're asking for $4,500 a month in escrow.
When you say that it was, okay, but part of the reason it's significantly below is because of the relationship of the parties, one to the building owner and to the business, right? I mean,
May I make an observation, Your Honor?
yes, sir.
It seems like this rental thing is really something that's going to be going on in the circuit court in terms of what's salary and what's rent. And there has not been a request in this case for money damages. It seems to me that the right thing to do is to either make a formal motion with lots of explanation in it, or leave it for the circuit court, which is what I think would be the appropriate thing. Because I can't imagine the circuit court people aren't talking about money damages. So,
Your Honor, may I respond?
Sure.
MCR 4.201 for escrow orders does not require that it be just
I know.
rent. You're allowed to ask for escrow in possession to recover property. So we are asking that the court exercise its powers and grant an escrow.
Right. Here's what I'm going to do, folks, and it's not by any stretch of the imagination exact, but I've taken into account what everybody has indicated regarding what the value of the property is, kind of formulating in my mind the relationship of the parties as to why that occurred, taking out what part of that is salary and doing in that. So what I'm going to do is I'm going to order escrow in the amount of $3,600 per month. The defendant would need to pay $2,400 for July and then $3,600 per month thereafter. I need a date. What's 3 months out?
October 10th, 8 a.m.
All right, at 8? Oh, okay. So what I will do is I will set this at October 10th.
Yes.
October 10th, 2025. The time that I'm going to give you at this point is 8 a.m. It will be, but we'll have, because our docket isn't set out that far yet. And then we will be able to give you a more specific time there.
That's
Okay.
for the pretrial October.
Yes.
At 8:30.
I said it at 8.
It'll be.
At 8, but you'll get a clarification.
placeholder.
Yeah. Okay,
Thank you, Your Honor.
thank you,
very
folks. Group 5 Management versus Sequoia Graham.
Good afternoon. Once again, Your Honor, Robert Weiss appearing on behalf of Group 5.
Ms. Graham?
Good afternoon, Your Honor.
Good afternoon. All right. And where are we on this case?
What's owed as of this point in time including court costs, is $940.
How much is monthly rent?
Monthly rents, well, agency pays part of it.
$775.
Huh?
$775.
Is your portion?
Yes.
Okay.
And
So basically, when you say 940, basically what I have owing is July plus court costs.
yes, but I made a
Basically.
payment, so it's not 940. And I'm sorry.
Hold on.
Sorry.
I mean, she did what she said she was gonna do when she was here in June. And
Yeah,
that
she
is
did.
basically try to get the balance paid, but then July kicked in,
Yes.
still had the court costs.
Yeah,
Okay,
she made
So-
she made a payment of $475 on the 10th. I think that's the last payment we're showing.
I'm sorry. I made a payment this morning. It might have not kicked in, so it should be
Okay.
maybe $890 now.
okay, how much did you pay this morning?
Just $50.
Okay, you paid what you could.
Yes.
Okay. All right. So that 940, that's inclusive of court costs, Mr. Weiss?
Yes, Your Honor.
Okay. So let me ask you this, Mr. Graham, when can you get that paid, you think?
So my plan is to make another payment of $100 this on the 19th of this month.
Okay.
And then on the 25th is the next time I get paid. I plan on paying off the balance of the rest
On the
that's left.
25th?
Yes.
Okay, let's do it this way then. So you don't have to keep coming back and forth and I can lock in the figure for you, okay?
Okay.
So I'm gonna find that there's no tribal issue after hearing. I'm gonna grant a judgment for possession for the total amount of $940. Okay,
Okay.
so hold on. And so normally the writ date or the date they could seek eviction or you'd have to pay by is the 21st. You get paid on the 25th
Yes.
deal? Okay. So what I'm gonna do is
I'll do you one
Great
better,
day.
Your Honor. I'll give her to the 29th.
I was gonna give her you're giving her to the 29th?
Yes.
Well, I'm always better than you. I'm gonna make her writ date the 30th.
You do that to me all the time, Your Honor.
I know. I'm not gonna let you show me up.
Thank you, Your Honor.
All right, so you get it paid by then. And either way, quite frankly, at the end of the month, but the 30th is good because that way you can get it paid. You'll be done, then you can start working toward this.
Thank you.
All right.
Would that
Thank
be,
you.
Here,
Thank you.
Your
Have a
Honor,
great
would that be
weekend.
after hearing or consent?
that would be after hearing.
Okay, thank you.
All right.
I'll fax it
Thank you.
over,
Have you too.
and I'm gonna hit the road.
All righty, sir. Take care. Safe
Okay.
travels, please.
Thank you.
Onyx Real Estate Solutions versus Joshua Detzler.
Good afternoon, Your Honor. For the record, Neil Chanis appearing on behalf of the plaintiff.
Detzler?
Yes, sir, I'm here.
Okay, I just had to have you come up on my screen. Okay, how much is owing at this time, counsel?
Your Honor, we have presented and already submitted to the court a consent order for conditional dismissal that's been signed by the parties. We've
Yes.
agreed to convert the case to a termination of tenancy, and Mr. Detzler is going to vacate the premises on or before July 31st, 2025. I explained and checked box 4B as well as Michigan Court Rule 4.201J. And again, Mr. Detzler has actually docu-signed the document.
All right. Sir, is that all correct?
Yes, but I do have a question as far as
Okay.
the dismissal. Does the termination is that basically an eviction or?
No, what will happen is that this case is what's called conditionally dismissed for the court's purposes. As long as you fulfill the terms, which is to vacate the premises on or before July 31st, then it will be converted into a permanent dismissal. If you don't,
Okay.
then what will happen is they will file a judgment plus an order of eviction, and that's where it will show as an eviction.
Okay, understood.
Does that make sense to you? Okay,
Yes,
did
it
you
does.
have any other questions regarding this?
Nope, that was it.
All right. I will sign off.
All right.
Mark this file as conditionally dismissed, and folks, thank you for working it out.
Thank you, Your Honor. Have a good
All
day.
right, have a good one.
All right, have a good weekend. Guys.
By the end of this hearing, Judge Simpson has demonstrated two different styles of judicial decision-making, each tailored to the facts before him. In the first dispute, he declined to accept either party's proposed escrow amount at face value. Instead, he analyzed the business relationship, separated salary from rent, acknowledged the pending circuit court litigation, and crafted a middle ground escrow order of $3,600 per month. Whether either side views that figure as ideal isn't the point. The objective was to preserve the property's financial interests without deciding issues that properly belong in the parallel business case. The later landlord-tenant matters reveal a different judicial priority. Rather than immediately escalating to eviction, Judge Simpson carefully examines payment history, upcoming income, and the tenant's proposed timeline before extending the writ date. That isn't favoritism. It's an exercise of judicial discretion aimed at encouraging compliance while still protecting the landlord's legal rights. The final case offers another practical lesson. By approving a conditional dismissal instead of entering an immediate eviction judgment, the court creates an opportunity for the tenant to avoid an eviction record by honoring the agreement to vacate. It's a reminder that negotiated resolutions can often produce better outcomes than prolonged litigation, provided both sides follow through. Looking across all three matters, one principle stands out. Courts rely on evidence, legal procedure, and credibility, not labels or assumptions, to reach fair decisions. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.